Good morning, everyone. Thank you to our webinar this morning on national origin discrimination and limited English proficiency. There haven't been very many trainings on national origin discrimination. It's usually offered, and that's how I've generally done it, as part of other trainings. But it certainly merits its own, webinar just on this topic. And hope everybody finds it really helpful. Just before we get into the content, again, webinar is being recorded. Questions go into the chat. You can turn on closed caption if you need it. And this webinar provides general information. It's not intended to provide legal advice as specific situations. If you have that, please contact our office. I'll have the number. You can see it listed down below, 313-579-FAIR. FAIR is 3247, or info@fairhousingdetroit.org. The video, again, is going to be posted on our website under services and resources. Videos of other webinars and conferences are also listed on our website. Again, big thank you to Mishta. This is part of our 2023 training programs. There's other topics on our website as well that we're offering for Mishta, and we appreciate their support and sponsorship of these webinars. Just go real quickly in terms of what we're going to be covering. We're going to first define national origin, and then we're going to look at fair housing national origin claims, and then we're going to look at what kind of inquiries can be made as to immigration status. That's a real hot button question for people today. And then we're going to look at national origin discrimination in persons with limited English proficiency. And we're going to see a real tight relationship between national origin and limited English proficiency. And then we're going to go through just some examples of fair housing enforcement when it comes to national origin discrimination, look at the legal theories, and then case studies. We're going to conclude by going through some resources. I've got a lot of content. I may not go into great detail on each of the slides, but you will have the opportunity to replay the webinar and focus on the slides that you think are important or you want to review a little bit more closely. First thing is, what's national origin? What is national origin? And here's a question, kind of started with a question. Do you have to be first, second, or perhaps third generation to bring a national origin claim, or are there any limits at all as to how many generations you can go back to be protected? How far back can you go for a national origin claim? What do you think? Anybody? What would you say? I can even allow you guys to talk. So how far back do you think you can go? What do you think? Lisa, what do you think?
Maybe 2 generations.
Yeah, see, that's not clear, is it? Anybody else? Couple generations? I mean, after, I guess Lisa's getting at the point, at some point you're assimilated. We'll talk about that too. If you become American, you can no longer claim national origin claim. What do you guys think? Well, let's see what the Supreme Court told us. Let's look at that. And by the way, I appreciate people speaking up. Go right ahead, please speak up. Share your thoughts and ideas, please. So question here is, the Supreme Court in an earlier employment case defined national origin as a country where a person was born, or more broadly, the country from which his or her ancestors came. So they really did not drop off at a certain point. So we can go all the way back. A classic example would be American Indians. It'd be tough to say exactly. I mean, I suppose genetically in that maybe Asia, maybe they crossed over from, what would be Soviet Union into Alaska, and then came into the US or what was America at that time, but it's not real clear, right? But certainly American Indian is covered as someone if there's claims under national origin discrimination. So it's no limit as to how far back it goes. And I think really the focus is really on the respondent, the person engaging in the challenge action or discrimination, how they viewed someone. more than where that person or how many years their or their family or their ancestors have been in our country. So it's a good question. I'm glad the Supreme Court answered it. We don't have a ton of guidance from HUD. We do have some helpful guidance, but sometimes I'm going to draw a little bit on the EEOC policy. Employment discrimination is an analogous context, and the courts that are deciding fair housing claims are also deciding employment claims, and they don't often they use the same standards in that. But the EEOC defined it as national origin, very, very broad definition. Denial of equal employment opportunity because of an individual's or his ancestors' place of origin, or because the individual has the physical, cultural, or linguistic characteristics of a national origin group. And here's how they kind of broke it into 4 parts. National origin claims can arise if someone is married to or associated with persons of a national origin, or they have membership in or association with an organization identified or seeking to promote the interests of the national origin groups, attendance or participation in schools, churches, temples, mosques, generally used by people of a particular national origin group, or because an individual's name or spouse, his name is associated with the national origin group. So you can see that it's a very, very broad definition that the EEOC uses. And that's just how I put it, right? But it's important really to know that all fits within the umbrella of national origin discrimination, right? Someone who's married to an Indian person who's from India would be covered because they're of their association. So it's very, very broad in terms of its coverage. And also EEOC notes place of origin may be a country or even a former country. The place of origin could be the United States. It can even be a geographical region that was never a country, but nevertheless associated with a particular national origin group. Another one, national origin group or ethnic group, is a group of people sharing common language, cultural ancestry, race, or other social characteristics. Hispanics, Arabs, Roma, right? Romans are ethnic or national origin groups. Years back in this country, there's quite a bit of discrimination against people from Italy. That was what led to the adoption of Columbus Day, because there was so much discrimination against Italians years back. So EEOC got just a little bit further. They break down, they have a great guidance, enforcement guidance on national origin discrimination. Break it down into 5 categories. There is ethnicity is because someone, for example, someone is Hispanic, or discrimination because someone who does not belong to a particular ethnic group, less favorable treatment in place who are not Hispanic. National origin also can be triggered or coverage because of physical, linguistic, or cultural traits. There could be adverse employment action because of an African sounding accent or traditional African style of dress. There's been recent cases now about hair. African type hairstyle could also be grounds for a national origin discrimination claim. Also perception, we'll talk about perception in just a minute. Just a perception that someone is from a particular country or a particular national origin group, or perception that someone's from the Middle East or Arab ethnicity, regardless how they identify themselves. There can be association, which you mentioned earlier, because their association with someone as a particular national origin. The way to understand a lot of fair housing and civil rights law is to think of race. Race is always a really, really good example. If someone is white and they're discriminated against because their association with someone who is Black, that would be discrimination against both, right? And so you can get source of income coverage. You can have source of income coverage because someone is associated with someone of a particular national origin or ethnicity. And the last one is citizenship status. We're going to talk quite a bit about that. Discrimination based on citizenship status, if it has a purpose or effect of discriminating or putting an adverse impact or effect on persons of a particular national origin. The interesting too is that there's a big overlap between the national origin discrimination claims and claims of color discrimination. Why? Because discrimination, often they're two are joined in the same case. Discrimination based on color is often added to a claim of discrimination based on race or national origin, generally because the skin tone of the victim of discrimination is thought to be a contributing factor to the discrimination. And there can be discrimination of the color of the skin rather than because of race, light skin, the darker skin, African Americans. It can also exist if there's discrimination from South and Central Americans and so forth, or India. And it's also, they point out it's a mistake to assume that because the complainant and respondent are both Black or both Hispanic, that there can be no prohibited discrimination between them. Absolutely, there can be. So often, not always, but there can be different skin color or complexion, which is associated with national origin. And so you're going to see often in cases, those two claims will be joined. So let's look at fair housing and claims of national origin discrimination. And here's the first question. Does a person have to be a citizen to bring a housing discrimination claim? Do you have to be naturalized? Or can you be really a resident of another country or citizen of another country and bring a housing discrimination claim? If someone lives in Mexico and they go across the border into Texas and apply for, a apartment and get turned down, right? Because they're Mexican or because they speak Spanish, what do you think? Would that be discrimination? Do you have to have citizenship status? How about immigration status? Does that matter as well?
No.
No. Right. No, it doesn't matter. And here's guidance. HUD has FAQs back in July 2012. Does immigration status affect whether a person is covered by the Fair Housing Act? No. Every person in the US is covered, protected by the Fair Housing Act. Immigration status has no effect on the right to bring a Federal Fair Housing Act claim or rights under Federal Fair Housing Act. Any kind of discrimination is illegal, regardless of the victim's immigration status. So it can be brought, claims can be brought by US residents of a particular national background or origin, or by residents of other countries based on discrimination that occurs in the US. So the real question is whether discrimination occurred in the US, excuse me, not the citizenship status of the person bringing the claim. We're going to see that in just a second. The Fair Housing Act permits any person to bring a discrimination claim. Section 1982, we're going to see in a second, has a requirement that someone be a citizen, but Section 1981 permits claims to be brought by all persons. And Michigan, our state law, provides protection for all persons. And here's really, this decision is based on the text of it. Here's a copy of Section 804 of the Fair Housing Act, or parts of 804 of the Fair Housing Act. Notice that it's unlawful to refuse to sell or rent after the making of an offer, or refuse to negotiate for the sale or rental, or otherwise make unavailable or deny a dwelling, residential dwelling, to any person because of national origin. There is no citizenship requirement. There's nothing on immigration status or anything of that nature. So, and you see again in 804B and 804D, it says any person. 804C, the language isn't there, but it's clear from the intent that to bring a claim under the Fair Housing Act simply provides protection for a person. And other parts of the Fair Housing Act defines person to include not only individuals, but corporations. It's really broadly, any kind of legal entity can bring a fair housing claim. But for our purposes here, you do not have to be citizenship or immigration status is not a factor in deciding whether someone can bring a claim under the Fair Housing Act. And so it is as well under Section 1981, the Congress, after 13th Amendment freed slaves were not able to buy and sell property, enter into contracts, and so forth. So Congress passed the Civil Rights Act of 1866, and then it got amended in 1870. There's two sections to it. There's 42 United States Code, Section 1981. This deals with contract rights, and 1982 deals with housing. We're going to see 1982 on the next slide. In terms of 1981, Contracts are important because a lease is a contract, a mortgage is a contract. There's employment contracts. There's, if you want to go into a hotel, you have a contract. So it's very, very broad, goes well beyond housing, but it certainly includes housing. And you can see at the definition of B, make and enforce contract includes making, enforcing contracts, making, performance, modification, and termination of contracts. Anything contract related, if there's discrimination occurring, it can violate section 1981. And 1981 covers race, ethnicity, race and ancestry are the main categories that are covered under 1981. It doesn't have the number of protected class categories as the Fair Housing Act. But the point here is that under 1981, all persons within the jurisdiction of the United States, meaning anybody who steps forth on the soil of the United States, has the same right in every state and territory to make and enforce contracts. You can see very, very broad, as enjoyed by white citizens. So you can see the kind of racial component because it's the immediate post 13th Amendment legislation that Congress passed. That was certainly, again, intended to give freed slaves the opportunity to enter into contracts like any other citizen, enjoy white citizens, to put people on an equal footing. So you do not have to be a citizen to bring a claim under section 1981. 1982 is different. It's really the broadest fair housing law, but it doesn't cover national origin. It's limited to citizens. All citizens of the United States have the same right in every state and territory as enjoyed by white citizens to inherit, purchase, lease, sell, hold, and convey real and personal property. That's a bedrock fair housing law. There are no exemptions to it, just that there is a citizenship requirement. So immigration status and that would matter when it comes to section 1982. That's why we mostly see claims under 1981 when it comes to national origin. So here's what is covered under 1981 and 1982. Prohibits discrimination based grounds of race. Caucasians, white are covered. You can see McDonald versus Santa Fe addresses that. Color, ancestry, or ethnic characteristics. It doesn't apply. Sections 1981 and 1982 do not apply, strictly speaking, to national origin. If someone is alleging a national origin claim and they want coverage under 1981 and 1982, the claim will be dismissed. So in order to bring a claim under 1981, 1982, you've got to use color, ancestry, or ethnic characteristics. Can't use national origin per se. Say, well, what's the difference between ancestry and national origin? Sometimes not much. What's the difference between national origin and ethnic characteristics? Probably not much at all, but use the magic words if you want coverage under section 1981 or 1982. So it's kind of a little trap for people if they're not careful. And again, if someone, is not a citizen, the only claim that can be brought is section 1981, and you have to say either race, ethnic characteristics, ancestry, or color. Can't use national origin. If someone is a citizen, then you have the opportunity to use both sections 1981 and 1982. Elliott Larson, Michigan law, has the same, tracks the language of the Fair Housing Act. I try to highlight all the places where it says a person. A person shall not, on the basis of that person at the top under 1 is the person doing the discrimination. So I didn't highlight that. But a person engaging in a real estate transaction or a real estate broker or salesman shall not, on the basis of national origin of a person or persons residing with that person, I should have highlighted those, refuse to engage in a real estate transaction with a person, discriminate against a person in terms and conditions, refuse to receive from a person, right, an offer to engage in a real estate transaction, refuse to negotiate for a real estate transaction with a person, falsely represent that a property is not available for inspection, sale, leasing, whatever, when in fact it is available, misrepresentation, right? So you can see Michigan uses the same language of the Fair Housing Act. You do not have to be a citizen to bring a claim under Michigan Arts and Civil Rights Act. Unfortunately, I'm not aware of a housing claim that's been brought under national origin. It's just not used that often in Michigan, but it should be. It works real well. A couple quick case studies. Martin versus Patch, the Mexican citizen, notice the Mexican citizen, alleged housing discrimination based on race and national origin under section 1981 in the Fair Housing Act. did not bring a claim under 1982, again, because he's a Mexican citizen, not a US citizen. The court concluded her complaint was a discrimination based on citizenship. She had no claim under the Fair Housing Act, doesn't cover citizenship, but her claim of alienage discrimination were actionable under Section 1981. In the Espinoza case, plaintiff alleged had a member of a property association had a citizenship policy. Plaintiff alleged it violated 1981 and the Fair Housing Act based on alienage and national origin. According to the court, Section 1981 reaches private discrimination based on citizenship, and Section 1982 reaches only race discrimination. So you can see how these kind of the interplay between these laws, and attorneys have to be real careful in terms of which law that they use. How about this? Can a national origin discrimination claim be brought by an American? Can someone from this country bring a national origin discrimination claim? What do you guys think? What do you think? Well, we saw that a white citizen can bring a claim for discrimination under Section 1981 and 1982. That works. But for national origin discrimination claim, do you have to be from another country? Or can you be a lifelong citizen? Maybe your family, you have no identification with any country other than this country, the US. Can you bring a national origin discrimination claim? What do you guys think? What do you think? Well, the answer is yes. Looking at Title VII employment discrimination cases, national origin has been interpreted to include discrimination against American workers in favor of foreign workers. In other words, if an employer prefers foreign workers to American workers, that would be a national origin discrimination claim. Does that sound far-fetched? No, not really. I remember an old case out of Chicago. There was a Korean, about playing into stereotypes. It was Korean cleaners that hired by word of mouth. And in 15 years, they only hired 7 or 8 Korean individuals, because if you're hiring by word of mouth, you're only going to appeal to people of the same language group. And that was per se discrimination. So yes, everyone is covered under civil rights laws, right? You can't prefer or disprefer any national origin group over another. Everybody has to be on an equal footing. And here's getting some key questions, hot topics today. What kind of inquiries can someone make or ask as to immigration status? What can someone ask? Housing provider, what can they ask? Well, first off, HUD's Office of Fair Housing and Equal Opportunity, FHEO as we call it, is the one that handles housing discrimination under the Fair Housing Act. And HUD makes it real clear that they don't ask about immigration status when people file complaints. There was one time, I forget the part of the country, I think it may have been Texas or something. There was a fair housing organization that was just working so hard, right, to encourage, reach out to Hispanic groups, get them to file complaints, inform them of the Fair Housing Act. They made a lot of progress. And then ICE came in and had a big movement and just dried it up. So then all the complaints just completely stopped, because people see HUD as part of the federal government and they think that they're going to get reported. HUD FHEO does not do that, not in the least. That's not their mission. That's not their goal. They want to have an open door when it comes to discrimination complaints, but it's hard to get that message out, or people are just so mistrustful. But no, they will not report someone who files a fair housing complaint. If someone then turns around because someone, say a respondent, receives a fair housing complaint from someone who, has questionable immigration status, and they want to report them to ICE or whatever, that would be actionable as retaliation because someone made a fair housing complaint. All right, so here, the real penetrating question: how about, can landlords ask for immigration documents? Well, it's clear that they can ask for documents to determine whether a renter meets criteria for rental, so long as they're doing it and the same policies applied to all potential renters. right? They can ask for identity documents and credit checks and so forth to make sure that they have the ability to rent. However, a person's ability to pay rent or fitness as a tenant is not automatically connected to their immigration status. If the procedures in place by the landlord is being used to screen potential tenants or root out existing tenants on citizenship or immigration status, it may violate the Fair Housing Act prohibition on national origin discrimination. The policies, whatever is used, must be consistent. If the landlord, housing provider asks for information from one person or group, they must ask it for all applicants and tenants. They cannot be treated differently because of their national origin. We're going to get into a little bit more detail on this as well and look at a couple recent cases dealing with this question. State and local law, right? Does the Fair Housing Act apply in town, city, or state, even when there's no local law that provides the same protection? Yes. Local laws may provide fewer or additional fair housing protections, but that does not affect in any way the coverage of the Fair Housing Act. And really, I wouldn't have normally put this in, but I was meeting with some people. I'm not going to name the city, but they were city commissioners. They weren't council members, but the name they use is commissioners. And they really didn't know that the Fair Housing Act applied, reasonable accommodation, reasonable modification provisions applied to their local zoning decisions. They did not know. Sometimes they think that the Fair Housing Act does not apply. It is under the supremacy clause. It has priority over any contrary state or local law or local state law or ordinance. So yes, it absolutely applies. Everyone is subject to the Federal Fair Housing Act when it comes to how they're treating people based on national origin or their immigration status. Here's the question. May a landlord require that all adult residents of the property have a social security number? What do you think? Can they ask for a social security number? Why does a landlord need a social security number? What do you think? What do you think? Well, look at a recent case raising just this question. Is that reasonable? Sorry, you don't have a social security number. You can't rent here. Oh, you have someone who has moved into your unit. They don't have a social security number. They're an adult. They must leave or we will evict. Is that how it goes?
Well, if they have like a green card or something that represents proof of potential permanent residency.
So what you're proposing is that why not have an alternative, right? How about an alternative?
Yes.
You guys agree? What do you think?
Yes, alternative.
You guys agree with the alternative? Yeah, now let's look at a recent case and it absolutely correct. This one was filed in, I think, 2020, and it recently conciliated, settled in 2022, just a few months ago, or maybe not even that long, maybe like a month ago. So anyways, in the spring of 2019, two people, Ernesto and Corina, found a perfect apartment in Aspen Grove Apartments owned by CM Bucks Landing, managed by Residential Management. Residential Management is the main defendant. They met the income and requirements for the apartment, but they were denied because Residential Management strictly enforced the policy requiring all adult residents to have a social security number. So Ernesto had one, but Corina did not. She was lawfully present in the country, but she was in the process of applying for a social security number, but did not have one. So she reached out to the Housing Equality Center of Pennsylvania, which conducted an investigation. And what they did, as went on, ended up settling it. So what did they find out? That if you require someone to have a social security card, it ends up having an adverse impact. It would be excluding more people based on national origin. The effect in here, in this place, it was, I believe they were Hispanic. it excluded them and other Hispanics from renting. So it ended up, it conciliated, and part of the conciliation has a new policy. And the policy, again, how to prove conciliation, has a policy on the requirement of social security number or for a residential management company, but it's a really good policy as well. So they said they will not require to provide, they're not require a social security number or an individual taxpayer identification number, ITIN, as a condition of approving someone for occupancy or tenancy. So it just like you guys said, you're correct. It allows them, they agree to accept following alternative forms of identification for adults, applicants or adults living there. And you can see the list here: citizenship card, consulate cards, INS form, passports, and so forth. These are all acceptable alternative forms of identification. What does that do? It meets the needs of the management company to identify that person is really who they are, and also avoids any kind of screening out of people based on national origin. So it's a real, I think it's a great settlement, and it's a nice to have that policy available. This would be one I would recommend housing providers adopt. Or if you have a complaint of national origin discrimination and you can get into a settlement agreement, have them adopt this type of policy. So well done, right? And that would allow them to continue to rent. And I mentioned this, and it's always true. Fair housing opens doors. It really benefits. The effect of this on Residential Management, Inc. will be to do what? Increase the pool of potential tenants, won't they? So it helps their bottom line. They can make more money under this policy than they would be by excluding people for not having social security numbers. So it should be treated as a win-win. So here's another important question here. National origin discrimination in persons with limited English proficiency. Very interesting, right? Limited English proficiency, or LEP, refers to a person's limited ability to read, write, speak, or understand English. Now, it's real clear, you know, no argument here. LEP, individuals who are LEP, limited English proficiency, are not a protected class under the Fair Housing Act, Section 1981, I suppose Section 1982, or Michigan's Elliott Larson Civil Rights Act. There is no law that protects a person with limited English proficiency per se, because it's not a protected class. However, fair housing violations occur because of the close nexus or connection between the limited English proficiency and national origin. What do you think? The number of people in the United States who spoke a language other than English at home nearly tripled from what amount in 1980 to what amount in 2019? What do you think from the census report? How many people in the United States speak some other language than English at home? The number is kind of amazing. Look at this. It was 23.1 million in 1980. It's now up to 67, close to 68 million, almost 1 in 5 in 2019. So very, very common for people to speak a language other than English. How about this? The number of people who spoke only English also increased. Isn't that something? Approximately 1/4. So we have an increase in the number of people who speak only English. It went from 187 million to 241 million in 2019. That's amazing. Here's a breakdown of the US. You can see where a lot of the limited English proficiency is located in large states. And it's a little bit hard to read here. Michigan, the numbers are between 300 and 400,000 people who speak a language other than English as the major language within their country, within Michigan. So it's between 300 and 400,000. Sometimes in some of this, a little bit hard to read. On the original site, the link there will have it. It's even more categories in some of the other states. So it's been increasing in Michigan. Here's the actual numbers. The unique thing is our office, we serve Wayne, Oakland, Macomb counties. Arabic is our second language to English, whereas throughout the rest of the state, we're not super high in Michigan in terms of speaking other languages, speaking only English. 9.2 million people, 8.4 million. Speaking a language other than English, 781,000 or 8.4%. Spanish is the largest at 2.7%, by Arabic, almost 1%, German, Polish, French, and so forth. So there is, quite a big population. Hopefully, webinars like this will get the word out in terms of what fair housing requires. So here's the real question. What are similarities between limited English proficiency and national origin? How would you distinguish between limited English proficiency and national origin? How would you do that? How would you distinguish that? Let's say someone is covered under national origin. What's the likelihood that they have limited English proficiency? Or flip it around the other way. Let's say someone has limited English proficiency. How likely do you think they are to be covered under national origin protections?
Very likely.
Answer is what?
Very likely.
They're very close, aren't they?
Yes.
They'd be very, very close, right?
Yes.
And that's recognized. HUD Office of General Counsel has guidance, LEP guidance from September 2016. Nearly all limited English proficiency persons are LEP because either they or their family members are from non-English speaking countries, right? It's like an obvious connection, but they show it. In the US, 34% of Asians, 32% of Hispanics are LEP, compared with only 6% of whites and 2% of non-Hispanic whites. Right, on place of birth, US, 61% of the persons were born in Latin America, and 46% of the persons born in Asia are LEP, compared with just 2% of persons born in the US. So housing decisions based on LEP, limited English proficiency, generally are going to connect up with race and national origin. And they're almost hand in hand connected. So it's very, very, very important when you look at policies when it comes to requiring any kind of a language requirement when it comes to housing, right? How do you distinguish people from different nationalities? Often by their language. Language derives from typically someone's place of national origin. And if there's any kind of disparate treatment, treating someone adversely because they speak a certain type of language is typically going to be national origin discrimination. Accent and national origin is also intertwined as well. So how about this one? Suppose a landlord refuses to rent to a Hispanic applicant, mistakenly believing that the tenant is Middle Eastern. Would this be discrimination based on national origin? What do you think? Landlord made a mistake, had a misperception. Would that be a violation? Oh, I thought the person was from the Middle East. I'm wrong, my bad. No problem? Or is that
That's
still
a problem because it shouldn't matter where they're from.
What's the intent? Right, the intent of the landlord was to screen out people who are Middle Eastern. And that discriminatory policy happened to be carried out mistakenly as to Hispanic applicant. I use that because that's a real life situation that occurred. So the answer is, right, that would be discrimination, right? In discrimination, national origin discrimination can occur even if the defendant does not know or is mistaken about precisely where the plaintiff originates. There's a couple cases there, right? So imagine a Title VII discrimination case which an employer refuses to hire a prospective employee because he thinks that the applicant is Muslim, The employer is still discriminating on the basis of religion, even if the applicant he refuses to hire is not in fact a Muslim. What is relevant is that the applicant, whether Muslim or not, was treated worse than he otherwise would have been for reasons prohibited by the statute. And you'd think, oh, I thought we were talking about national origin. Why are we getting into religion? Well, the same reason, right? Religion can be a factor with national origin. Certain areas, right, have different proportions of religious groups. So there can be times whereas national origin can correlate with race, national origin can also correlate with religion. At the bottom too, there's another site, that Smith case. Plaintiff brought a claim for religious discrimination based on his employer's perception that plaintiff was Jewish, even after plaintiff told his employer that he was Catholic. Court found a jury could find the employer perceived the plaintiff to be practicing Judaism and discriminated against him based on the perception. So the point is this, gotta have housing provider, employer, have to have, right, be policies, practices free from discrimination. Misperceptions, right, will not be a defense. This is a Michigan case. The plaintiff was Iraqi, had dark skin, perceived as being Muslim, and he listed all the things that occurred to him. They were kind of harassing him because of that. Look at this. In March 2010, there was a graffiti etched on the doors of a bathroom stall depicting two buildings similar to the Twin Towers with a plane hitting one of them, and a caption that stated plaintiff is learning how to fly. Really, that's terrible. After learning of the graffiti, the manager said plaintiff was oversensitive, emotional, and unable to take a joke. Right? The court held jury could find that the incidents or evidence of discrimination based on the perception that plaintiff was a Muslim. And that was that case then was permitted to proceed. All right, so let's go into some of the details on enforcing these type of claims, what kind of legal theories, an example of case studies. There's 3 theories of liability. We're going to look at the first 2. Disparate treatment that requires proof of discriminatory effect, or proof of discriminatory intent. It can be direct or indirect circumstantial. On the left side, there's disparate impact, requires proof of discriminatory effects regardless of intent. We're not going to discuss the other legal theories like reasonable modification and accommodation and so forth. They don't arise that often when it comes to national origin. I'm not saying they don't. For example, someone could deny someone a reasonable accommodation because of their national origin. That would be unlawful. It'd be unlawful as denial of reasonable accommodation, but also may have a disparate treatment component to it. So we're going to look at the first 2, disparate treatment and disparate impact. And here's examples. Kind of amazing when I, do presentations and list examples, they resonate with people. People experience these things and they just almost like they don't know that that was illegal. But examples of national origin discrimination, refusing to rent someone whose primary language is other than English. And it could even be if they turn somebody down because of their religion. Charging a different price or asking for additional documentation because of person's national origin. Steering people to or from or away from certain neighborhoods because of their ancestry. Prevailing to provide the same level of service, offering different terms on a mortgage or other financing. Blanket refusal to deal with LEP persons in housing contexts. And this is EOC would, or HUD will distinguish the housing context from employment. In an employment setting, maybe employees need to interact and language would be important so they can communicate effectively with each other. That's not a big concern when it comes to housing. When it comes to housing, how much contact or communication do you need to have with the landlord or property management company? Probably not much. And how much contact do you need to have with other tenants? Probably not much. So languages should not be a big deal at all when it comes to housing related matters. And even if you do, right, all they need to, LEP persons often speak enough English to get by or have a friend or household member who can provide assistance. Advertisements containing blanket statements such as all tenants must speak English, turning away applicants who are not fluent in English. Here's one too, ban on tenants speaking non-English language on the property. or discouraging people from using non-English languages. Right? The fact that people communicate in their own native language among themselves or their guests should not be a problem to a landlord or housing provider. Elective enforcement, right? Not, preferring or dispreferring one group or the other based on language, right? You can get the other ones. If at the bottom one, second from the bottom, if a housing provider is required to provide housing related language assistance under federal, state, or local law and fails to do so, that can be evidence of intentional discrimination. That applies to municipalities and it applies to government contractors, anyone receiving federal financial assistance. They must provide LEP services. If they don't, that would be intentional discrimination. That's a real one. Now, it doesn't apply to private landlords. They're not quite there yet. There's no requirement that they provide LEP services. So it's a little bit different. And the last one is kind of a unique one, selective use of criminal history as a pretext for unequal treatment based on national origin. Sometimes they'll do that. They will turn around and turn somebody down based on criminal record, someone of a particular national origin, where they're not applying that to others that are not within that particular national origin or scrutinizing more closely. And here's a case of disparate treatment. This goes back a few years, just outrageous, just outrageous. Respondent asked Hispanic applicant why she wanted to live in a Black neighborhood. She told her it was not a good idea because she might not feel comfortable, right? That would be what? Right? That would indicate a preference, suggesting to an ordinary reader or listener that a particular race is preferred or dispreferred for the housing in question. And that's what it did, right? Why do you want to live here, right? That's a violation. Even assuming, she said, she admits the neighborhood is predominantly Black and, based on the context of when that statement was made, that would constitute disparate treatment. Another example, this one is really bad. This is respondent came from a porch and addressed a complaint from a common driveway, right? She said that his people, as well as Mexicans, Blacks, and Vietnamese, were not allowed to live on that block. Complaints, I have a right to rent the house. Respondent pointed a finger at him, said if he did rent the house, he would have trouble. And you can see, said that they want to bring more Hmong friends around to see the house. Didn't want any Hmong, Black, or Hispanics living on the street. She said that she told the young man that came to rent this house that she didn't want him or any of his kind to rent it, or she would hate to see something happen if they did. Right, eventually they decided, to sell the house. The owner of the house decided to sell the house rather than rent it. A volunteer tester from a fair housing council spoke with respondent posing as a potential buyer of the home. And the respondent told him she didn't want any Asians or Hmongs living next door to her, even if she had to go to jail for expressing that view. Right. And while commenting about having him as a neighbor, the respondent say, at least you're better than Hmongs, or using the N-word. Outrageous. Right. And the court found what? It was unlawful interference, coercion, harassment, threatened interference. Right. They granted Mr. Lee was a complainant a right to attempt to rent a home without being subject to discrimination, harassment. Another one, this is just crazy. A landlord engaged in harassment against tenants, calling them uncivilized, MF Puerto Ricans, MFN blanks, Bics, and Ricans, telling them to go back where you belong. I'm going to kill you, you don't belong there. So the complaint got filed with HUD. Upon learning that the complaint was filed, believe it or not, the landlord interrupted the complainant's water and electricity service. This is blatant, right, discrimination based on national origin. Again, these are disparate treatment cases, directly treating someone adversely because they are members of a national origin. In HUD v. Simpson, complaints were dark complainant of Hispanic descent from Peru originally. Respondent engaged in a 2-year campaign of harassment based on national origin and color. I looked at that complaint. It's just, it's just disgusting. Constantly calling the city about them, complaining about this, complaining about that, like 15 times. I mean, one were just frivolous, one ended up being marginal, that the city wouldn't have done anything about anyways. HUD v. Ross, previous tenant testified landlord told him he did not want to rent to Puerto Ricans. Successful applicant testified landlord told me did not want to rent Hispanics because they played the music too loud, drank too much, and they're always on welfare and he didn't want the apartment being ruined. These are all examples of disparate treatment based on national origin. Disparate impact is a little bit different. This involves a facially neutral policy or practice that has a discriminatory effect because of national origin or another protected class, and it violates the Fair Housing Act and Elliott Larson Civil Rights Act if it's not supported by legally sufficient justification. Notice I've left out 1981 and 1982. You can't bring a disparate impact claim under sections 1981, 1982. 1981 and 1982 require proof of intentional discrimination. These claims do not require any proof of intent. There's a three-part test or standard for it. It's in HUD's 2013 disparate impact rule. The first one, the plaintiff has a burden of showing that a facially neutral policy or practice actually predictably results in disparate impact on a group or creates, increases, reinforces, or perpetuates segregation. And here are based on national origin. How do you show this? Typically census data to show that an LEP or other type of a policy has a disparate impact on race, national origin, or another protected characteristic. And the US Census Bureau, I got some of the data from the charts that you saw earlier, is a good way to find out, what the ethnic makeup or languages are spoken in a particular area, and that can be used to show that the looks like a facially neutral policy will result in a disparate impact or adverse impact against a group based on national origin. The next step is then, assuming that statistical proof is shown, then the defendant or housing provider has to show a legally sufficient justification. It must be necessary to see one or more substantial, legitimate, non-discriminatory interests, and it must be supported by evidence and not purely hypothetical or speculative. The key part, though, is that it goes to the third one. The plaintiff then has a burden to show another practice that has a less discriminatory effect that achieves the legitimate interest served by the policy. And examples in national origin cases, for example, English proficiency, is that a legally sufficient justification? Typically not necessary in a buyer-seller context because there's no ongoing relationship or need for the buyer and seller to communicate. Similarly, it's not likely in landlord-tenant context because communications are not particularly complex or frequent, right? Refusing to allow LEP borrower to have mortgage documents translated or refusing to provide the borrower translated documents that the lender mortgage broker has readily available is likely not necessary to achieve a legal sufficient justification. Another one would be restricting a borrower's use of an interpreter, requiring that an English speaker co-sign a mortgage likely not prove justifiable. Some states require that if negotiations for mortgage are conducted in non-English language, certain documents must be provided in that language. If they avoid complying with state law, that can give rise to a national origin violation under the fair housing laws. So here's the question, can housing provider require tenants provide original Social Security cards? We have a case where it said no. Can you require original passport, visa, I-94 or I-94W? Can you require this of all applicants, not just tenants on the lease? Can you now renew someone if it's not provided? Look at two quick case studies. This would be Reyes case has been going on for quite some time. It's now up on appeal again. But the mobile home park had a policy to require original Social Security card or original foreign passport, original visa, original arrival departure form to show their legal status in the US. If they didn't do it, tenants would not have their leases renewed and would be subject to eviction. And the justification the mobile home park policy claimed is necessary to confirm the application of the applicant's identities, perform criminal background checks, minimize loss from eviction, and they wanted to avoid potential liability for harboring illegal aliens and underwrite leases. Originally, it was enforced against a leaseholder, a tenant. Then they expanded it to provide for to all applicants 18 or older. If they fail to comply with the policy, the leaseholder, the tenants would have 21 days to cure the violation or vacate the unit. And they converted these leases where the documents weren't provided. They converted these leases to month and charged an additional $100 for each month of non-complying. The tenant failed to vacate the lot, and they're really planning to get it up to $300 a month. And the plaintiffs claim that the policy disproportionately removed Hispanic or Latino families from home in comparison to other groups, denying them one of the only affordable housing options in the community. Statistical evidence showed that Latinos comprise 64% of the undocumented immigrant population and 10 times more likely than non-Latinos to be adversely affected. And undocumented immigrants were 36.4% of the Latino population, only 3.6% of the non-Latino population. And they were, following discovery, it was shown that they were nearly twice as likely to be Latinos, twice likely to be undocumented compared to Asians, and 20 times more likely to be undocumented in other groups. 60% of the tenants were Latino. 11 of 12 tenants at the park were not in compliance with the policy. 91.7% were Latinos. The court said that the plaintiffs made a proof that the policy disproportionately impacted Latinos in violation of the Fair Housing Act. That case does not resolve, so I can't, tell you how it will turn out and what kind of policies will be adopted. This case really jumps out. Defendants have a 201 is CNY Fair Housing versus Swiss Village. So Swiss Village owned, managed a 201 unit apartment complex and a 30 unit apartment complex. Rescue Mission Alliance called and asked about available apartments. Their client's primary language is Spanish. A Rescue Mission Alliance caseworker took the call after the client had difficulty communicating with the rental agent. The rental agent asked whether the client would have an English-speaking individual living with the client. Get the idea, this is like an English requirement rule, isn't it? The caseworker said they wouldn't. The rental agent told the caseworker his client would need to live with someone who speaks English in order to rent at Swiss Village Apartments. The RMA caseworker said he was bilingual, be able to assist with the translation or interpretation as needed. But no, the rental agent insisted that the client must live with an English-speaking individual. The call ended. The caseworker then informed the plaintiff that Swiss Village Apartments had refused to rent to his client based on her limited English proficiency. And so the Fair Housing Center conducted 3 tests. The tester 1 called, identified herself as a caseworker, right? And caseworker interrupted, and the agent interrupted the caseworker, asked whether his client would have someone on the lease that with her that would be English speaking. If the client did not, we'd not be able to lease to her. Why? Because the lease is a 16-page legal document that the client would have to sign. I have to know that the client knows how to read that. Right? And also repeat a requirement that the client would always have someone that is going to either be an occupant or a leaseholder that will be able to speak English so they can communicate with us. Second test, inquired about the availability of 2-bedroom apartments, and the rental agent provided a tester with rental information. The call ended. And on the third test, they asked about availability of 2-bedroom units, and the agent asked if it would be for herself or someone else. She was a caseworker, and it said the same requirement. Must be an adult who can speak and read English. Right? The tester stated that she could help translate for her clients, but the agent interrupted and said, but you would have to actually live in the apartment. Right? And disparate impact claim, the English only policy has a disproportionate impact on prospective tenants based on national origin and race. Notice they combined race with national origin. I think national origin claim is stronger. And so they went to the US Census Bureau data on limited English proficiency by nativity and race, and conclude foreign-born residents are 500 times more likely than native-born residents to be excluded by their policy, and so forth. You can see the statistics here. Right? Foreign-born residents of the county at issue are over 50 times more likely than native-born residents be excluded by defendant's language policy and so forth. Foreign-born residents of the entire Syracuse metropolitan fiscal area are nearly 60 times more likely than native-born residents to be excluded by defendant's language policy. So the net effect of this policy, neutral policy, doesn't say anything about national origin, just as an English-speaking requirement. But the net, when it's applied, it would end up excluding who? People that are non-English speakers, which tend to be what? Right? Foreign-born residents. That's a clear violation. The district court said it have sufficiently alleged discrimination based on national origin and race. Court gave deference to HUD's Office General Counsel Limited English Policy guidance on Fair Housing Act LEP protections. You notice that? I mentioned, and a lot of trainings, I always show HUD policy in that. And time and again, courts do not have to follow HUD guidance and policy. That's not binding law. But in the absence of any other authority or guidance, they typically will consider that to be persuasive. I know when, the complaints that we receive and the enforcement that we do, we look to these policy statements and guidance. And if people are not following them, it's likely that that claim will proceed further. So it's very, very important to look at that HUD's Office General Counsel guidance, as well as HUD's guidance on Title VI as to LEP as well. And that's cited at the bottom. So they found that that was sufficient. I don't know if that case has been resolved yet or not, but the decision got issued in July of this year. So a couple of things. Well, what do you conclude? Like, so what do we know? First, we know that policies have to be examined, whether it's Social Security is a card, is a requirement in that. No, can't do that. You should allow, clear housing providers should allow alternative means of identification. When it comes to English speaking requirements and things of that nature, they're very, very suspect. They're going to have an adverse impact based on national origin. There's such a clear connection between limited English proficiency and national origin. That's going to be suspect as well. Hope, this is kind of helpful. I know I went through this probably pretty quick. I think I went through a little bit faster than I thought I would, but I think it's helpful. I know people are real busy. But I hope this gives you some idea of where we're at in terms of national origin discrimination, a little bit on the do's and don'ts for housing providers, management companies, property owners, and so forth. So the key guidance for national origin questions, first is it's a HUD policy, immigration status and housing discrimination, the FAQs, that's from July 2012. That deals directly with national origin. Much of the other guidance deals quite a bit with limited English proficiency. That's been a big emphasis at the federal level. HUD Office of General Counsel has that good guidance, which we mentioned, on Fair Housing Act protections for persons with English proficiency. That's actually mandatory reading as well. And then the DOJ has policy guidance on enforcement of Title VI, national origin discrimination, persons with limited English proficiency. And HUD has guidance as well, federal financial assistance recipients regarding Title VI prohibition against national origin discrimination. I'm not getting into great detail on that. That's really more for recipients under Title VI, meaning governments that really pretty much have to comply with it, or federal contractors. Quite a bit of detail. HUD's guidance has quite a bit of information. It lists like the 4-part test to decide whether interpretation services need to be provided. I consider those probably outdated today. Interpretation services are readily available, whether it's people that use American Sign Language or those that have various type of languages. You can easily contract out to get interpretation services as needed. It's not that costly. Rather than get into this, so the answer all of us should be yes, we provide it. We can provide sign language interpretation services readily available, as well as interpretation services for any language for people that we interact with. The ultimate goal in any fair housing case is to step back, take a look at the intent. Is the intent to rent the unit, make the home available, or is it to do the opposite? And if all the steps that are taken are done with the goal of trying to make housing provided in order to accommodate someone and get them to move in and so forth and be a successful tenant, you're not going to face a fair housing issue. It's when things go the other way that problems occur. Let me know in the chat if there's anything else you would like to know, any future training opportunities. Again, I have a listing of our MISTA trainings that are coming up. That's on our website. Our services, again, like housing complaint, there's intake, we do investigation, we do testing, enforcement, resolution, all provided free of charge. No complaint that contacted our office has ever been charged. We answer other housing related questions. I just answered a follow-up question for a municipality on dealing with bed buds and whether that applies differently to subsidized property as opposed to non-subsidized property, and how that relates to whether, you know, the status of the property and bus and transportation services and so forth. But they're available. I'll put the answer in writing. We do quite a bit of training and education. I'm setting up to do, for example, training rights out in Port Huron in April. And, you know, if you do not get the training education, we go on site, we provide the training, we answer questions, we can look at policies and make sure that you're in full compliance. We're not trying to hide anything. You know, if people don't, you know, get the training and education, it's because they're not asking us. But we're always making it available. We do charge a bit for it, but really not very much. Often the training education is grant funded anyway. So there's often, you know, often there's no charge. And again, please contact us 313-579-FAIR or on our website at fairhousingdetroit.org. Happy to respond to any time that you reach out to us. I want to thank you all for participating. I don't know if anybody has any additional questions on anything that's been presented. I will stop the recording and then people can ask questions freely without any recording taking place. Any questions before I stop the recording? Anything about what's discussed? Any questions or follow-up questions? Please let me know. Okay. I want to thank everybody for coming, and I want you to look forward and go to our website on training, you know, events and training, and see if there's any other training opportunities that you would be interested in, and please be sure to register. And I will post this on YouTube very, very shortly, maybe even today. If anybody wants to follow up or take a little closer look at some of the slides. Anyways, thank you all for coming. I appreciate it. Bye-bye.
Thank you.
Thank you.
Hi, Lisa.
Thank you.
All right, take care.